May the 10th.
Me too.
It's Friday.
Your Honor, if I may,
Yes.
he was here that day.
Okay.
He probably just got added to the docket.
That's what happened. I noticed the date on it was March 28th, so it wasn't in the...
It's in the computer now.
Okay, great. All right. May 10th, 2024 for review at 9 a.m.
Okay.
And I would suggest instead of relying necessarily on Prestera to send the report, that you show up with a report.
Okay.
In that day.
Like I said,
if they send it, that's great, but I would go ahead and have one with you just in case.
okay. Like I said, I'll be talking to my counselor today. He'll be calling me, so I'll talk to him about getting a report so I can get it here next time.
Okay. We'll see you back May 10th.
All right. Thank you.
Thank you.
State of Ohio recalls Sarah A. Woods for the review. I understand, Your Honor, that is here.
I was in the lobby with an ankle monitor client. I do not, may I approach Your Honor?
You may.
I emailed her report to John. All I have is a copy of the email if you want to see it on my phone.
That's fine. Here, she's compliant.
Yes, she is.
Okay.
She's making great progress.
Okay, great. Ms. Woods, can you hear me? We're recalling Sarah A. Woods, CRB 22-326 and CRB 21-686. Ms. Woods, can you hear me?
Yes.
All right. We got your report. It is an excellent report. So keep that up. If I don't know if you'll be able to in your program, but if you can work the community service down here on Saturday, on the next 2 Saturdays, you'll get double the hours, which would go a long way, to help you out in your case. And I understand that you've got some things in common pleas as well. But I'm going to reset this for May 31st, 2024 at 9 a.m.
All right, this Saturday, I won't be able to, it's my son's birthday, and I'm taking a pass to spend the night with him, but Saturday, I work in the evening, so I'll do my best to make it down next Saturday.
All right. Well, we'll see you back May 31st.
All right, thank you so much.
Thank you.
Thank you.
All right. If you've got an arraignment today, go ahead and come in the courtroom.
First time appearing, warrant, missed the hearing, needs to get in the courtroom now.
All right. I went over this with one defendant, but I want to go over it with everybody. I go over your rights before the court. You have the right to remain silent. You have the right to have reasonable bail issued on these cases. You have the right to an attorney. If it's a misdemeanor, anything other than a minor misdemeanor or a felony, and you cannot afford an attorney, you have the right to have an attorney appointed at state's cost on your case. I'll have to assess your income and dependents to determine that. You also have the right to have the state force the state to prove each and every charge beyond every element of the charge, beyond a reasonable doubt. When you hear your name called, come up to the table on the right, as you've seen other individuals do, and I'm going to ask you, I will read the charge to you, and then I'll ask you for a plea. You can enter 3 pleas, either guilty, not guilty, or no contest. A guilty plea means you're admitting the violation, you're admitting the facts of the case, and you'd then be found guilty. If you enter a not guilty plea, you are denying the allegations at this time, and then we'll discuss further whether you intend to seek counsel. If you enter a no contest plea, that means you are not contesting the facts surrounding the case, but you are also, at that point, if you enter the no contest plea, you're not contesting the facts surrounding the case, but agree that I can find you guilty if I think the state would have enough evidence. If you're unsure of what you should do, you should enter a not guilty plea. It preserves all your rights before the court. Again, everything is being recorded in here, so if you decide that you want to tell me about your case, it is all being recorded and then could later be used against you. So bear that in mind if you would call the first case.
State of Ohio versus Connor J. Harrison, case number TRC 24-813, A and B.
This is State of Ohio versus Connor J. Harrison, TRC 24-813, A and B. Mr. Harrison is present this morning. And Mr. Harrison, it's alleged that on or about April 22nd, 2024, in South Point, that you were operating a motor vehicle under the influence of alcohol, drug abuse with a prohibited, well, it says there's a prohibited alcohol concentration of 0.068, which is, okay. So
Yeah, I'm under 21.
You're at 21.
Yeah, I'll be 21 in 6 months.
Okay. That is a violation of Ohio Revised Code 4511-19B3. That is a first-degree misdemeanor. Maximum penalty is 6 months, or excuse me, that's actually a fourth-degree misdemeanor. Maximum penalty is 30 days in jail and a $250 fine. Additionally, you're charged with a taillight violation, or an illumination of rear license plate, violation of Ohio Revised Code 4513-05. That is a minor misdemeanor. Maximum penalty is $150 fine and court costs. How do you wish to plead?
Guilty, sir.
Okay. Additionally, and prior to accepting your plea, there's also if you enter a guilty plea, there's a 90-day license suspension that you would receive.
I understand.
Are you sure that that's what you wish to do here today?
Yeah.
Okay. I'll accept your guilty plea. I'll enter a guilty finding. I'm going to order 10 days in jail. I'll suspend them. You'll need to go do the 3-day driver intervention program in lieu of that. There will be a $150 fine with the court costs paid. There'll be a 90-day license suspension. And I'm going to order you to do 20 days or 20 hours of community service. You have any questions?
No, sir.
Okay. You'll need to see the clerk, and I'm going to order you 2 years of level 4 probation.
Connor, on the tail lights violation.
Be a $20 fine.
Thank you.
One cost. All right, you need to see the court and see probation, or see the clerk and probation.
Gotcha. Thank you.
Thank you.
State of Ohio versus John Scott Pfeiffer, case number CRB 24-216.
This is State of Ohio versus John Scott Pfeiffer, CRB 24-216. It looks like this matter was set for an arraignment on April 22nd of this year, and Mr. Pfeiffer did not appear for that arraignment.
I was in the hospital, Your Honor.
He's here today. Have you been given a copy of this charge, Mr. Pfeiffer?
My medical chart?
No, you've been given a copy of the charge.
Oh, okay. May I approach?
No.
He should.
Have you received a copy of the
You
charge?
should have already had it, Your Honor.
Maybe. I'm not sure where it's at.
Okay, well, I mean, did you receive it?
Yes.
Okay, that's what I was asking.
Oh, okay.
All right, Mr. Piper, it's alleged that on or about April 21st, 2024, you did with purpose to deprive Speedway, the owner of property or services, knowingly obtain or exert control over said property or services, to wit, miscellaneous merchandise without the consent of Speedway. That's a violation of Ohio Revised Code 2913-02A1. That's theft. It's a misdemeanor of the first degree. Misdemeanor of the first degree carries a maximum penalty of 6 months in jail and $1,000 fine. How do you wish to plead?
Not guilty, Your Honor.
All right. I will accept your not guilty plea. Do you wish to hire, are you going to hire an attorney?
No, sir.
All right. Do you wish to be considered for a court-appointed attorney?
Yes, sir.
All right. Are you working?
Not right at the moment,
You
no,
have
sir.
no income?
No, ma'am. No, sir.
Okay. I will appoint Attorney Roger Smith. And you can sign a $1,000 signature bond. And Mr. Smith will come over and help you with that.
State of Ohio versus Carrie Beth McCoy, case number CRB 24227.
Did you set a pretrial date yet, Judge, for Mr. Pfeiffer?
Oh, no, just a second. Mr. Smith, you're available on May 17th?
I am, Judge, yes, sir.
Okay. Pre-trial is going to be May 17th at 10 a.m. All right. This is State of Ohio versus Carrie Beth McCoy, CRB 24227. Ms. McCoy, it looks like you have a copy of the charges.
Yes, sir.
Ms. McCoy, it's alleged on or about April 25th, you did knowingly with purposes to deprive Walmart, the owner of property or services, obtain or exert control over said property or services, merchandise, without the consent of the owner. That is theft. It's a violation of Revised Code 2913.02A1. It's a first degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. How do you wish to plead?
Not guilty, sir.
Okay. Do you intend to hire an attorney?
I need a court-appointed one, please.
Okay. Are you working?
No, sir.
No income at all? All right. I'll appoint Mr. Morford, who's in the courtroom. It appears you already posted a bond.
Yes, sir.
I will continue the bond that you posted,
Thank you, sir.
and we'll set Mr. Morford, what's your availability for May 17th?
I believe I'm here, Judge. Give me 1 second.
Or excuse me, May 24th.
I'm here.
Okay. I'll set a pretrial, May 24th at 10 a.m.
State of Ohio versus Justin Michael Reaper, case number CRB 24226.
This is State of Ohio versus Justin Michael Reaper, CRB 24226. I have a note here that Mr. Morford, you were hired on this matter.
Yes, Your Honor.
All right, so, has Mr. Reaper received a copy of the charges, Mr. Morford?
He just did, Judge, and we'd waive reading.
Okay, reading is so waived on the charges. I presume you're going to be entering a not guilty plea?
Yes, Your Honor.
Okay.
We've asked for OR bond. He is a veteran, served in the Middle East, several tours of duty.
He's actually already posted a bond with Mr. Sowards.
Okay.
So I will continue the bond that was posted.
We can do,
And I will accept the not guilty plea.
first week of June for the next week.
Super June.
And Mr. Morford, I saw you're available on the 24th. Would that be?
Yes, my client's asked me if we could do it in June, Your Honor.
If you would waive, if you want to waive time?
We waive time, yes.
Okay. I'll note the time waiver by counsel. Is there a date in June that you wish to come back?
Any day the first week.
How about June 7th?
That works.
I'm here then too, Judge.
All right, set that for June 7th, 2024 for pretrial at 10 a.m. Not guilty pleas entered.
You're good.
Yeah.
All right, cool.
Thanks, Your Honor.
Thank you. All right, we're ready for pretrials at this time. There might be some more arrangements coming.
Mr. Cooper, is Justin Haslem here?
I don't think it's actually Haslam. I think it's Haskin.
Haskin?
Yeah, it's a Haslam on them.
State of Ohio versus Destiny D. Anderson, case number TRC 231701, A and B.
If you have a pretrial, come in the courtroom.
And he's going to be on, the Hascamp's going to be on the screen. I think he said noon. He thought it was noon.
Well, we can certainly pass it until then.
I could text him and let him know.
That's no worries. Destiny N. Anderson.
Roger Smith?
We need Mr. Smith and Mr. Roger Smith in the courtroom. Here he comes. He's kind of popping on the wheelchair. All right, this is State of Ohio versus Destiny Anderson, PRC 231701 A and B. President of court is Ms. Anderson, along with her attorney, Mr. Smith. State of Ohio is represented by Assistant Prosecuting Attorney Philip Healy.
Approach, Your Honor.
You may.
That's fine, Judge. I've spoken to my client, given the evidentiary issues we discussed at the bench. She is in favor of the amended charges I anticipate the prosecutors want to make.
Okay. How's your client wish to plead to the,
No contest, Judge, a stipulation of facts sufficient to find her guilty.
I'm sorry, I didn't work.
it's not really an amendment, we're treating it as our first offense. Okay. Is there a proposed resolution on the first offense?
I would assume she'd be allowed to go to school in lieu of jail time and fine up to the court a driver's license. Well, she is alleged to have refused the test, so it would start today, the driver's license suspension. Ask for limited driving permit. That'll work.
Okay. Is that correct, Mr. Hill?
Yes, we're not opposed to any of those things.
All right. B, I will accept there was a no contest plea with a stipulation of finding a guilt. Is that correct, Mr. Smith?
Yes, Judge, that is correct.
I accept the no contest plea. Under guilty finding, there'll be 20 days in jail, all suspended, to the 3-day PIP school, be a $500 fine on the OVI, and a $20 fine on the B case, the Mark Lanes. I'll order the court costs to be paid, and 2 years level 4 probation here with the court, and with the refusal, that's a 1 year, it's a 1 year license suspension. Actually, Mr. Smith, I believe it would have started on the date of the offense.
We have no objection to that, Judge, to get credit for the date of the offense.
So I will start the suspension back to November 12, 2023.
And then other than work, Judge, that's one thing you need a permit for.
Work and groceries for this week.
Work, and of course groceries for the family. She'll have to do some shopping, and then to the court for community service and review hearings.
I will grant a permit for occupational purposes, for court purposes, and any medical or family purposes. All right. Anything else?
No, Judge, I'll send her over to probation.
All right. Ms. Anderson, you'll be to meet with probation. Excuse me, I am going to add on 30 hours of community service.
Yes, sir.
As the court standards. All right, Ms. Anderson, you'll need to speak with probation and then possibly the clerk as well. Thank you.
If anyone has a cell phone on you, turn it to silent.
State of Ohio versus Manning Joe Hall, case number CRB 24116.
This is State of Ohio versus Manning Joe Hall, CRB 24116. Ms. Hall is present here in court today with her attorney, Mr. Roger Smith. State of Ohio is represented by Assistant Prosecuting Attorney Philip Healy. This matter is set for a pretrial.
I'm not marijuana.
I do want to do that, just do this if there's a time. Suspended. So what does it say? Trial. Judge, she would enter a guilty plea at this time. This is a Walmart theft case. She indicates to me she was drug screened last time she was here.
That's correct.
And it was positive for marijuana, but no other illicit substances, is my understanding.
I've got a note, there was buprenorphine and benzodiazepines also positive, but it said that she had stated there was a prescription, but I don't know if that has ever been provided to the court.
She indicates that she does.
I can provide it, yeah.
Okay. Ma'am, is it your intention then to enter a guilty plea today?
Yes.
Okay. I'm going to accept your guilty plea, but I do want to have you screened prior to sentencing today on this. So I'm going to have you screened one more time today, and then I'll have you back out after the screen.
Okay.
But I will be recalled later in the docket.
State of Ohio versus Brittany Smith, case number CRB 24171, CRG 22673, A and B. Brittany Smith. Brittany Smith.
So the State of Ohio versus Brittany Smith, case number CRB 24171. Mr. Smith, her attorney, is here present, and Ms. Smith is not.
Judge, I don't know where she is today. I did get a DVD from Walmart in my folder today. I was going to ask for a continuance, but I don't know where she is. If a warrant were to issue, I ask court to please hold her for a week, and I will get her in Monday or Friday if I'm able to avoid the warrant being issued or being served.
Okay, Mr. Heel?
We're not opposed to the warrant being withheld for 7 days to see if she can come in.
I find that Ms. Smith has failed to appear. Order the warrant to issue within 7 days. And Mr. Sowers is on this, so he probably wants to reach out to Mr. Sowers.
Give her a step out and text him. Thank you, Judge.
Thank you, Mr. Smith.
State of Ohio versus Cody J.W. Mead, case number TRC 23152, A, B, and C, TRC 221690, A and B. Cody Mead. Mr. Smith?
Yeah. So the State of Ohio versus Cody J. Mead. We've got TRC 23152, A, B, and C, TRC 221690. A and B, and TRD 222101, A and B. President's court today is Mr. Mead, with his attorney Mr. Smith, and Mr. Heald is representing the State of Ohio. Commission made.
Your Honor, I was made aware this morning when the lab came back that Mr. Mead had tested positive for THC. His levels had went up more than they were, so that is not reflected on that report, yes. We are going to work with him, and all the clinical team is made aware of it.
Was everything else negative?
Yes.
Okay. Overall, other than that, it's a good report. Mr. Smith, Mr. Heald, where you want to go?
Judge, I would hope we could come back again. Obviously, he's not ready to graduate the program. I would ask we keep monitoring the case, come back perhaps that May 17th date or a date after. Assume Mr. Heald has no objection and the court docket's not so crowded that day.
Are you here the 24th?
I can't imagine I would be. Let me double check. Yes, I've already got 2 cases set that day.
Okay. I'll go ahead and set that. That's a much lighter docket date. I'll set that.
I can
set
do
this
that.
matter back May 24th for pretrial, 10 a.m. Mr. Mead, you had a little bit of a setback, not the end of the world. You delve back into your treatment and get it corrected.
And this is sentencing, Your Honor.
It's on the pretrial docket, but it's actually,
reviewed.
yeah.
So many distinctions, it's hard to...
I just tell them to be here at 10 o'clock, then we figure out what it is.
Yeah, he's been sentenced on all the cases, I think.
The old,
Yeah,
yes.
this is on, they're older cases.
Because I know there's a rubber band around his several files. It's in the clock.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
State of Ohio versus James A. Kelly Jr., case number CRB 24152, A and B. Mr. Stratton.
This is the State of Ohio versus James A. Kelly Jr., CRB 24152, A and B. Looks like Mr. Kelly is present in the court with his attorney, Mr. Stratton. State of Ohio is represented by Mr. Field.
Your Honor, we're not able to resolve this with the prosecutor, so we'll just ask to be set for a jury trial.
Okay, have you filed a jury demand yet?
I believe I have, yes.
Okay.
I'm sorry, I tried to text Judge Capper to see what dates he's unavailable, and I haven't heard back from him.
Well, let's do this then, Mr. Stratton. I'm going to set this for one more free trial.
Okay.
That way it'll allow allow Judge Capper to come back and be able to figure the availability. I don't have his availability either. So let's set this for May the 24th, unless you're unavailable.
Yeah, it's a bad day, Your Honor.
You available May 17th?
Yes.
We'll set it for 5/17 for final pretrial at 10 a.m.
Your Honor, I'm not going to be available that day. And I think probably since I will be the one trying the case, I'd like to be here for the final pretrial.
May the 10th?
Yes, Your Honor.
All right. Mr. Hill, does that work for you as well?
That works, yes, thank you, Your Honor.
Sorry, Mr. Hill, I take for granted that you're typically here every court date, so.
Yeah, and when I'm not, it's kind of like a total solar eclipse or something.
Yeah.
Rare.
All right, I'll set it for final pretrial on May the 10th, 2024, 10 a.m., and then that will allow Judge Capper to have some dates if it can't be resolved that day.
Thank you.
Thank you, Mr. Stratton.
State of Ohio versus Brandon McClaskey, case number CRB 22565.
We're just going to do a jury trial.
Sorry to hear that.
Yeah.
The State of Ohio versus Brandon McClaskey, CRB 22565. Mr. McClaskey's present, City Counsel, Mr. Stratton. And Mr. Field is representing the State of Ohio.
Yes.
Thank you.
Okay.
She said it was already paid. It's like a criminal management. Yeah. I don't know which case. I don't know which case number it is. She wants him not to have to be responsible. He's
Yeah,
not
that's
taking
fine.
it. We gotta figure out what case number it is. Because he's got several.
So Desire can have you on his program also? Okay, all right, great.
All right, Mr. Stratton, have you had an opportunity to review the report?
Yes, Your Honor.
All right, Mr. McClaskey, it's kind of a mixed bag here. Overall, you're doing well, but you need to put more, sounds like you need to put a little more effort into this. You know, if you don't want to be in treatment and you're just doing it because you're being forced to, you can always spend some time down in Lawrence County Jail for that. So, not going to do anything like that today because overall, like I said, it's a good report, but you need to, they're indicating that you need to focus more on working the program instead of just getting through the program.
He has an ankle monitor from Ironton Municipal Court and it's felony court. Sorry, pardon me, Your Honor. Felony court, so.
Okay. Well, see, it sounds like that if they're having you in treatment as well, then you probably want to make sure you're doing what you're doing because then it wouldn't be jail, it would likely be prison over there. You understand?
Yes, sir.
Okay. Mr. Hill.
Well, Your Honor, Ms. Lily Chapman is here, and she was a victim on 22 CRB 565, and there was an order of restitution in that case, and she says that she's satisfied at this point and doesn't want that order anymore. So we would ask that the prior order of restitution be considered completed.
Okay. Ms. Chapman, is that correct?
Yes, sir.
Okay. Then,
I don't see that any payments have been made on it, is that correct? Just like that.
I mean, you got a drink.
Yeah, I got cash.
But it was
Payment.
drink.
No payments were made to the court, thing, right? There's a record of it.
all right, well, so you're asking, Ms. Chapman, you're fully satisfied and you have a right to be heard on that, and you're indicating that no payments were made through the court, so we have no record of anything being paid here today.
Okay.
Today.
Yeah.
And you're fully satisfied with that.
Yeah.
And you're asking the court to essentially set aside the restitution amount.
Yes.
Okay. Well, I will then today make note that you appeared and requested the restitution, or requesting that you're, or indicated you've been fully satisfied. With restitution. And Mr. Stratton?
We have no objection to that, Your Honor, but we'll just ask to be sent for another pretrial, see how he's doing.
Okay. You available May 31st, Mr. Stratton?
Yes, Your Honor.
Okay. I'll set another pretrial. May 31st. May 31st at 10 a.m.
Very good, yeah.
Thank you.
State of Ohio versus Carlos J. Polite, case number CRB 2418.
All right, this is the State of Ohio versus Carlos J. Polite, CRB 2418. Mr. Stratton is present with the defendant, and Mr. Hewitt is here on behalf of the State of Ohio. Gentlemen, where are we on this matter?
Your Honor, I believe the prosecution has agreed to a 90-day continuance of this, and if there's no problems, to dismiss it in 90 days. Also, I understand that the alleged victim in the case possibly wants a modification of the temporary protection order, which we're in agreement with.
Is Kaylee Harris here?
Yes, sir.
Yeah, I'm here.
Can you come up?
Mr. Hill, is what was represented about the 90-day continuance accurate?
I want to make sure, but I believe it to be the case. I spoke with Ms. Harris, the alleged victim, and she is agreeable. You don't want a protection order. Protection order maybe was already dismissed. She says they're doing relationship, marriage counseling, whatever you would call that, and our proposal is that they would continue to do that, and that Mr. Is it Polite or Polite?
Polite.
Mr. Polite would agree as part of this for it to be an order that it get done, and then at a later date, come back and he would have something in writing saying that it was completed, and then at that time, we would be agreeable to a dismissal of the charge upon the payment of court costs.
Your Honor, is there a completion date for your counseling, do you think?
I don't know. It's kind of like therapy in a sense. You kind of just go in when there's issues and stuff, talk about things through the week, work on things. Like it's a.
I don't know if there's an end
Yeah.
date for that.
Mr. Hill?
Well, and that happens sometimes, understandably, that it's because of the fact that everybody can work on stuff their entire lives. But at least we would want something in writing saying that they'd been taking part in it successfully and done well at it.
Okay. Yeah, we have no problem with that.
No issue with that? All right. So what I will do then is I will note that, first off, July 26, 2024. That's about 90 days out. How is that for your calendar, Mr. Stratton?
That'll work.
All right. So I will set that then, instead of coming back at that time, and if there are no further problems,
That's for me to give the court.
and the parties continue counseling, then it will be dismissed upon payment of court cost at that time.
Yes, Your Honor. July 26th.
All right, thank you very much.
Thank you.
State of Ohio versus Sherry Priest, case number CRB 24195.
The State of Ohio versus Sherry Priest, CRB 24195. Matter separate pretrial.
Sorry. Your Honor, the state has agreed to a 90-day dismissal on this one also, so if there's no problems for 90 days, we'll dismiss it.
Mr. Gill?
Drug protection, too. She wants drug protection. It's automatic for court.
Yeah, first time I come to court.
That's why I want you to come.
I remember Richard Polachek. Is that a relation? I didn't know how many Polacheks there were. It's not a common name. Okay, so you're okay with holding the case out for 90 days and dismissing it if there are any further problems?
Yeah.
Okay. Well, okay. Well. Okay, so you can, there's not going to be any further problems between you two.
It's funny that he's already agreed to it. That's how he has to talk about it.
Yeah. You want that? Okay. Now, the second part is a 90. Sometimes we have those charges and stuff. Trying to get convictions.
Okay, I'm well.
Okay. Then what we'll do is a 90-day. Let's make sure
There was a protection order. Okay, so I think there's more than that.
in the meantime, you'll be able to talk.
And then just come back in 90 days and review.
No, 90 days and we'll dismiss. Yeah.
So do I come with this?
Yes.
Okay.
And we'll have to pay court costs.
Okay.
For like 130.
Well, we don't have our dollar charges.
It's part of the dismissal.
I'll have that Sunday.
Sorry, Your Honor, I needed few moments to speak with Ms. Polachek, and she does want the protection order to continue at this time, but we are in agreement with a 90-day continuance, and if there aren't any problems between the parties between now and then, we would not oppose the dismissal of the charges upon the payment of court costs.
Okay. Mr. Stratton?
That's fine with us, Your Honor.
All right. I already know July 26th works for your calendar, because we just set the last one there, so July 26th for pretrial at 10 a.m., and I'll note that if there are no further issues with the parties, it'll be discussed upon payment of court costs at that time.
All right, thank you.
Thank you.
All right. Yes.
State of Ohio versus Kristen M. Preston, case number TRC 171120, A and B. Kristen Preston.
The State of Ohio versus Kristen M. Preston, TRC 171120. Ms. Preston is present today with her attorney, Mr. Stratton, and Mr. Heald is representing the State of Ohio. Mr. Stratton.
Your Honor, the only thing we had left was community service to do on this case.
On the 30th, I have 24 hours completed, and then this is my, because they haven't updated it. So this is from the 17th when I finished my last day.
Okay.
But it has,
Did you work with the
I have an update of now on this. Last one update I got was October 5th, 2023. All the fines paid off. Are all the fines paid off on the last update I got was October 5th, 2023? It is.
trying to figure out, because on there it only has the 3 days, but this does.
The last update I got was October 5th.
I'm not seeing any cost.
Okay.
Yeah, it was just community service is all she
Yeah.
had to do, Your Honor, so.
And Your Honor, if I may, just for the record, it is complete. I talked to Mr. Wood about it.
Okay.
If it's not updated in the future, I'll make sure it's updated.
Okay.
I don't know.
That should conclude the case, I believe.
That would, yeah, that should include your case, Ms. Preston. Your case is now complete, and you are discharged from any further duties with the court.
Awesome. It's been a long ride, y'all.
Done.
Is there like any paperwork or anything I need, or I'm good?
You're good?
Okay.
Yeah.
All right, thank you.
Good job.
Thank you.
State of Ohio versus William R. Price, case number CRA 23703, CRB 23704.
No, just got to know where I can see her next to
It's the State of Ohio versus William R. Price, CRA 23703 and CRB 23704. Mr. Price is present with his attorney, Mr. Stratton, and Mr. Heald is representing the State of Ohio. This is a preliminary hearing and a pretrial.
Your Honor, he has had some issues of getting into Shawnee Mental Health. He has now an appointment next Tuesday, so I just ask that we set this in a couple weeks. That's okay with the prosecutor.
Mr. Heald?
We're okay with that, with the time waiver.
Yes, no wait time.
I will note the
Just put a letter back.
time is waived, and I won't take this out too far. You're available the 10th, Mr.
Yes.
Stratton?
Yeah.
Right. May the 10th, 2024, for pretrial and preliminary hearing at 10 a.m.
All right, thank you.
Thank you.
State of Ohio recalls Mandy Jo Hall, case number CRB 24116.
Should be automatic.
The State of Ohio versus Mandy Jo Hall, CRB 24116. We called this matter or after having a screen. Mr. Smith, have you had an opportunity to review the screen?
I did, Judge. I took a look at it. My client indicates she's currently at Mohajan Therapeutics. Treatment and AOD treatment and mental health.
Okay.
So I assume the court would have her talk to provider given that screen, but she's already actively participating with Mohajan.
Okay, is anybody from Mohajan here? Okay. All right, Ms. Hall, here's what I'm going to do. I'm not going to go ahead and sentence you today. I'm going to have you come back and let you continue to do some treatment. When you come back, you're going to need to have something from Mohajan showing that you're in treatment and that you are participating in some type of progress report.
And I'll have her bring her scripts also, Judge, for the buprenorphine and the, what was the other? What was it? Oh, the benzodiazepam, yes. The Klonopin, which is a benzo. She'll bring scripts for those two. And
Okay, so
I'm here the 24th, Judge. If you want to go out further, we could go further.
we can do the 24th.
Okay.
So I'll set this May 24th for sentencing. At 10 a.m.
See you then. Thank you, Judge.
Thank you. Before we go to the jail, while the jail's getting ready to get ready, we'll take a quick break, and I'll be right back on the record here in just a few moments. Court's in recess.
Too far. That's time because Mr. Maloney, you served on
Thursday? I think there's only 3 people in there.
others, there's 4 now.
4.
Yeah, my son, he doesn't have 13 hours.
They'll get it.
I'll take care of it.
I'll take
You
I'll see it.
Okay.
I checked with Susan, made sure it's turned.
He did.
I said, well, here's the problem, I gave it to him, common please, because like me, stick them in a file, you don't see it. That's what it's like. Shit. Yeah. They probably don't recall. You used to do that all the time. I remember you doing that. For years you did it. Yeah. You're gonna check your.
So she's probably happy to.
Oh, I'm sure, I'm sure.
So I think I'm gonna say something. But I think
She's just.
You get some windshield time, you can drive, put on the radio, put books on tape or whatever.
Here's the thing.
Don't mind driving so much.
Approximately when this will go in.
I do sometimes, if I go to a mall, I can beach or something.
Well, I think like November.
Let's sneak out there, that will surprise me.
I'm apparently covering that as sex to the verdict. Okay, what do you want to do with this today?
I didn't know it was on.
You're welcome. She's in the back.
Okay, well. That's not how you say it.
It's an adventure.
Oh, yeah, she left.
No, she was pretty subdued. I told her.
You want me to see what I thought?
Yeah, she's got a slap on the police officer.
She immediately, she the one I said,
Same day or something.
So what do you want to do with her?
I want to, well,
You got
Deputy Chancellor will be here. He met her.
Okay,
She's been here.
yeah, I remember.
So it's kind of
She
bad.
didn't want to chat about she had laid out.
Maybe this is a situation where
Tasky Center,
could treat her or something. Yes.
She want to go over the.
But I want to get the officers in
Make
here
an
too.
appointment, I'll see. I didn't look at this, but for today, we'll just get you new thing.
So
No, but she was coming, she was, she didn't find, she didn't want that.
preliminary
She's
wave,
got it.
I'll keep it here.
Oh, Lord.
He was one of the first charges. The word was incorrect, so they, no, they didn't. The right to refile. So she probably has. She had 4 burglary. He's saying she came to the house. She was. Lawrence County Municipal Court is now back in session. She was pretty cool. She, but yeah, she wanted to read all those State of Ohio versus Sean Crabtree at the Lawrence County Jail. Danielle Hams on that.
So the State of Ohio versus Sean Crabtree, CRB 22494 and CRB 24228. Mr. Crabtree, can you hear me?
Yes, sir.
All right. I'm going to go over, have you been provided copies of the charges?
Yes, I have.
All right, so first I'm going to go over CRB 22494 with you. And I'm going to ask you to enter a plea. You can either enter a guilty plea, not guilty, or no contest plea. Guilty means you're admitting the violation. Not guilty means you're denying the violation. And no contest plea means you're not admitting the violation, but you're not contesting the facts surrounding the violation, and then I can find you guilty in the event that I think that the state has enough evidence. The first charge is, states on about July 13th in Union Township, you did with purpose to deprive Andrew Hutchison, owner of property or services, that you knowingly obtained or exerted control over said property without consent of the owner. That's a theft. It's a first-degree misdemeanor, violation of Ohio Revised Code 2913-02A1. Maximum penalty is 6 months in jail, $1,000 fine. The second charge in CRB 24228, on or about April 25th, you deprived Walmart in Fayette Township of property or services, merchandise, without consent of the owner. That's also a first-degree misdemeanor theft. Maximum penalty, 6 months in jail, $1,000 fine. Do you understand the charges against you?
I do. I don't really recall that 22 was that. I do understand what you're saying.
Okay. How do you wish to plea?
At this time, I would like to plead not guilty because it's 122, so I can keep some time to talk to lawyers, figure that, you know. The one more thing I would like to say, I am sorry.
Hang on, don't, everything you're saying is being broadcast and recorded in court, and I don't want you to say something necessarily against your interest.
That's fine.
So I will accept your not guilty plea to both charges. Do you have money to hire an attorney?
I don't have any time to bring it. I mean, I do, but I don't. I got $1,000, that's all I got. That's like, come on, anyway, $1,000.
Okay, are you currently, are you employed?
Yes.
Do you get paid hourly?
Yes.
How much do you make an hour?
Well.
How many hours a week do you typically get?
30.
Do you have any dependents?
Yes, I agree with you.
Okay, I'm going to find that you qualify for court-appointed counsel. Is Mr. Stratton still here? Does anybody know?
I don't know, he was still here, you want me to check?
All right, I'll appoint Mr. Stratton to represent you in both cases.
Okay.
And Mr. Heald, if you'd like to be heard on the matter of bond.
Yes, Your Honor. I'm looking at this case from 2022. I have a suggestion, and this might be something that Mr. Stratton would need to speak with his client about first, of course. It sounded to me like Mr. Crabtree was beginning to confess to the Walmart theft. If he wanted to go ahead and plead to that today, we would not oppose an OR bond. We would delay sentencing, and then he could then contest the other. The other theft is from, it says a sober living facility, and I don't know which one, but if he wanted to consult with a lawyer about that one, and we would address it at the next hearing, then we would be okay with an OR bond, if he wanted to do that.
Your Honor, so we got two thefts?
Two thefts.
Okay. One's Walmart.
Both in one.
One's from 2022 from some entity, and the other one's a Walmart theft from just the other day, April 25th, just yesterday.
Your Honor, allow me to call down there and talk to him.
Sure. Mr. Crabtree, your attorney is going to call down and speak with you about a partial proposed resolution. So we will recall your case after you've had an opportunity to speak with him on the matter of bond. Okay?
Thank you.
Thank you.
State of Ohio versus Danielle Ham, case number CRA 24229, and James A. Markham Jr. on deck.
Okay, Ms. Ham, can you hear me?
Yes, ma'am. Yes, sir, I'm sorry.
Have you received a copy of the charges?
I just read through the one.
Okay.
Total.
All right, so I'm going to go ahead and go through the charge with you. This is case number CRA 24229, State of Ohio versus Danielle Ham. Ms. Ham, it's alleged that on or about April 25th in Rome Township, you did by force, stealth, or deception trespass in an occupied structure or a separately secured or separately occupied portion of an occupied structure that is a permanent or temporary habitation of any person, when any person other than the accomplice of the offender is present or likely to be present with the purpose to commit therein a criminal offense. It's a violation of Ohio Revised Code 2911.12A1. That's burglary, a felony in the second degree. Ms. Ham, do you have the money to hire an attorney?
No, sir, and I might add.
Well, hang on. Everything that you're saying is recorded here, and so that can all be used against you and in a future hearing by the state of Ohio. So just answer the questions that I'm asking you, and then your rights will be protected. Okay?
Yes, sir.
Okay. You don't have the money to hire an attorney?
No, sir.
Are you currently working?
No, sir. I'm trying to file for my social security.
Okay. So you have no income presently?
No, sir.
All right. I will appoint Attorney Luke Steyer to represent you. Mr. Steyer, this is an F2, it's charged as an F2 burglary. It's Danielle Ham.
Okay.
Mr. Hill, do you wish to be heard on the matter of bonds?
State would request a $50,000 cash assurance bond.
I'm going to just ask Ms. Ham, is there a cash surety bond you believe you could reach?
I could sign my own OR because I don't have.
That's not what I asked you, ma'am. I'm asking, is there an amount of money you think you could post?
No, sir.
Okay.
I did not do.
I'm gonna caution you against talking about the case right now. We're on the record. I'll contact you later on and talk to you. Right now, we're just dealing with bond.
Okay.
Okay. Recognizing that with an F2, a cash and surety bond is likely, and doesn't sound like we can make one, I'm gonna ask to have this set at the first available date.
Okay. What I will do then, I'll start with the bond that was requested by the state, $50,000. Mr. Steyer, if you wish to, after speaking with her, if you wish to have this recalled on the matter of bond, I'll certainly consider it. And
I'm on the docket on the 3rd, if that's a possibility. I don't know what day she came into custody.
we could set that for the 3rd.
Okay.
It appears that it was the 25th was when she came into custody, it appears, so we'll set it for a preliminary hearing on May the 3rd at 10 a.m. And Ms. Ham, Mr. Steyer is probably going to reach out to you here shortly, and he's going to discuss the matter of bond, and if he thinks that it would be appropriate, he may call it back before the court to request a different bond in the matter, and I'll certainly hear that today if that's the case, if there's a bond that he thinks would be reasonable you can make.
Because, sir,
Well, hang on, I'm going to advise you.
I can assure you I did not do this.
Again, ma'am, I'm going to ask you to please stop talking about the facts of the case.
Yeah.
We are on the record.
So Mr. Steyer's going to reach out to you down at the jail, and then we'll go from there, okay?
Okay, sir.
If we don't recall the case, your case will be heard on May the 3rd. It's the first available date to get there for a preliminary hearing at 10 a.m.
Okay.
Okay?
Thank you.
Thank you.
That's all. State of Ohio versus James A. Markham Jr., case number CRD 24-230, A, B, and C. Oscar Cremings is on deck.
Okay.
Your Honor, I'm here on behalf of Mr. Markham. I've received a copy of the charges filed in this case. We'd waive a formal reading of those charges and enter a not guilty plea.
Okay. Mr. Markham, can you hear me?
Yes, sir.
Okay. This is CRB 24-230, A, B, and C. State of Ohio versus James Markham. Present in court is Mr. DeLauder on behalf of Mr. Markham. Mr. Hill is representing the state of Ohio. We've waived formal reading and entered a not guilty plea.
We will, Your Honor. I've received a copy of the charges in this case. We'd waive a formal reading, enter not guilty plea. I've also discussed with Mr. Hill the matter of bond in this case. Mr. Markham's family has been able to post a $5,000 bond for him. I think Mr. Hill's agreeable to that, and we'd ask that stands in this case.
Is that correct, Mr. Hill?
He's already put up a bond of $5,000. Yeah, we're okay with that amount standing as his bond in this case. We're going to ask for a protection order, so we probably need to have a discussion as to if he has some other place to go.
Yes, he does, Your Honor. Some of his family's in the courtroom today. He understands the nature of the charges and will agree to the temporary protection order while this case is pending.
Mr. Lawton, you will come back.
So it doesn't really matter to me. I know that the court has a hectic docket on the 6th, but I'm going to be here on May 6th, May 20th, and June 2nd.
May the 20th looks like it would probably be the better day.
Okay.
The 6th is about as loaded as it can get.
All right.
So I'll set this for May 20th at 10 a.m. for pretrial. There'll be a $5,000 cash surety bond for all cases. And there's going to be a protection order issued by the consented parties. And that will need to be signed before he...
Will they send that down to the jail for him to sign?
Yes.
Yes.
Okay, so Mr. Markham,
Yes, sir.
they're going to send down some paperwork you have to sign to agree to stay away from the complaining parties while this case is pending. Sign that form when it gets down there, and then your family will come down to release you, or to pick you up here in just a little bit, okay?
Okay, yes, sir.
All right. Thank you, Your Honor.
Thank you.
Is that all for Mr. Markham's case?
That's all for Mr. Martin's case.
State of Ohio recalls Oscar Cremines at the Lawrence County Jail. Excuse me. We don't recall Oscar Cremines, we're calling Oscar Cremines. And Sean Crabtree will be on deck.
All right, Mr. Cremines, can you hear me? Could you hear me? Mr. Cremines, can you hear me? You're muted, I believe. Okay, can you hear me?
Yes, sir.
All right. This is State of Ohio versus Oscar Cremines, CRA 24231, PRD 201040, PRC 193082 A and B. Mr. Cremines, did you receive a copy of the new charge?
Yes, sir.
All right. Mr. Cremines, I'm going to go through that with you. It's alleged that on or about April 25th in Fayette Township, you did knowingly obtain, possess, or use heroin, a Schedule I controlled substance. The amount of said drug equals or exceeds 1 gram but less than 5 grams. 2 wet, 1.07 grams. It's a violation of Ohio Revised Code 292511, AC 6B, possession of heroin, felony to the 4th degree. Felonies to 4th degree carry a maximum penalty of 18 months in jail. Okay. 18 months in jail and a $5,000 fine. Is Mr. Steyer still here?
I am, Your Honor.
Okay. This is Oscar Cremines. My understanding, Mr. Steyer, is you're standing in for Mr. Tyler Smith in this matter.
Okay.
He has a new charge. It's a felony for possession of heroin. Mr. Cremines, can you afford to hire counsel?
Yes, sir.
Okay. Do you have any income?
Yes, sir.
Okay. Mr. Tyler Smith, I believe, has been representing him. Is that correct, Mr. Steyer?
I'm not certain. I actually represent Mr. Cremines in common pleas court in a case
Okay.
that is currently dormant because of an alleged failure to appear. It's in front of Judge Ballard, so I do not believe it will get back in front of the court before the 8th of May, because Judge Ballard's not holding a docket next week.
Okay. I see here Mr. Thompson, looks like, was representing him on the old cases at one point. So what I will do is I'm going to go ahead and appoint you, Mr. Steyer, on all cases.
Mr. Cremines, do you know if you have a holder from Common Pleas Court?
Yes, it is.
Okay. That was my expectation, but I wasn't certain if it had been activated.
Hey, Luke, what's his charge?
It's some level of arson. It's involved in an allegation of trying to burn copper wires.
Mr. Hill, do you wish to be heard on the matter of bond?
Well, I was just being informed by Mr. Steyer about what the common pleas case is about. It sounds to me like he's going to be in jail anyway until he can be brought back before common pleas court if he had failed to appear previously.
Allegedly.
Allegedly. And it may also be that because of the allegations there in common pleas court that this charge might be kind of subservient to that charge or can be consumed with it on a dispositional kind of thing in common pleas court. But in the meantime, we want to make sure that he does get before the common pleas court. So we would ask for a $5,000 cash or surety.
Mr. Steyer?
Your Honor, I'm going to reserve arguments on bond at the moment, because I believe they're moot due to the holder from Common Pleas Court. Once that is figured out, we have a better idea what we need to do here.
Okay. I will do a $5,000 cash as surety bond for Mr. Cremines. And Mr. Steyer, I think we just set one for the 3rd.
We did, so I'm going to be here that day.
We're getting a little crowded, but I think time-wise, we don't have much choice, so it's going to be set for May the 3rd, 2024 for preliminary hearing at 10 a.m. and pretrial on the older cases.
State of Ohio recalls Sean Crabtree, case number CRB 24228 and CRB 22494. Sean Crabtree at the Lawrence County Jail.
Okay. This is State of Ohio versus Sean Crabtree. This is, we were here already, there were not guilty pleas entered. On behalf of Mr. Crabtree, Mr. Stratton has had an opportunity, I presume, to speak with Mr. Crabtree now and has asked for this matter to be recalled.
Yes, Your Honor. Mr. Crabtree is under the supervision of Sauter County Probation at the moment. So until we had the time to talk to them, we just asked that this be set for another pretrial.
Okay.
I asked that
we reserve the matter of bond at this point.
Yeah.
Mr. Heald had made a proposal, I believe, so I guess I'll start with Mr. Heald. What's your thoughts on bond, Mr. Heald?
Well, the allegation of the theft was just from yesterday, and so, the fact that we have that allegation and he's on community control in Sauter County is kind of concerning. Plus, we've got another charge from back in 2022. I guess our thought previously was that we'd like to, may not be able to do what we planned before. We would ask for a $2,500 cash or surety bond.
Mr. Stratton?
Your Honor, he's on supervision from Sauter County. They have not placed a holder on him. If he's released on a signature bond, he would go straight to Sauter County, report this to Sauter County Probation. That process needs to be done before we are to plead to anything. Mr. Heald is willing for him to sign his bond on a plea. So whether he pleads, whether he doesn't, I think a signature bond is just going to guarantee his return, and we know where he's at. I mean, he's on supervision up there. Sauter County resident, he'll be back. He's went through that system up there in the past year, I believe it was.
Hey, I'm sorry. Take me out on it. I was County resident. I was right after the court out.
Okay, so he's a Rawlings County resident, but So, Your Honor, I asked for a signature bond in this matter, and if he doesn't have a holder, so Soda County he must have done everything he's supposed to do in Soda County if he doesn't have a holder, so, or a motion to revoke.
Okay, I'm gonna set bond at 2,500 OR for both charges.
We can come back relatively soon.
We could come back on the 10th,
That's fine, Your Honor.
if that works for you, Mr. Stratton.
May 10th, Mr. Crabtree. Thank you, Your Honor.
Be set for pretrial at 10 a.m. Mr. Crabtree, you'll need to, Mr. Stratton, did you get contact information for Mr. Crabtree?
Mr. Crabtree, could you give me your phone number?
Yes, sir. 740.
Okay.
44 1089.
Thank you, Your Honor.
Thank you. All right, Mr. Crabtree, you're going to need to stay in contact with your attorney. And in the event that you would fail to appear without just cause, the next time you would certainly have a cash surety bond. I'm giving you the benefit of the doubt on this because you're under supervision and that these are misdemeanors, but if you don't show back up, there'll be a cash surety bond and it may be something that you won't be able to make. You understand?
Yes, sir.
Thank you.
We're finished with the Lawrence County Jail at this point, Ryan. State of Ohio versus Christopher W. Roadcap, case number CRB 2420, CRB 23646, PRC 211172, AG&C. With your honor, this is what we have a special prosecutor consider.
Mr. Ashworth, can you hear me?
Yes, sir.
Good, it's good to see you, Mr. Ashworth.
Good to see you, Judge.
All right, this is State of Ohio versus Christopher W. Roadcap, CRB 2420, CRB 23646, PRC 211172, A, B, and C. This is set for a pretrial today. Present in court is Mr. Roadcap with his attorney, Mr. Warren Morford, and present on behalf of the State of Ohio is Special Prosecutor Ryan Ashworth. Gentlemen, where are we on this matter?
We have this case set for trial, Your Honor. It's continued for some procedural issues, personal reasons, and I think we're only here today to reset the trial date and to the extent that there'll be a plea or a resolution that will occur before then.
Okay. Is there a date that you have proposed, Mr. Ashworth?
I have not. It's up to the court. I don't think it's just a bench trial, so usually Judge Capper puts those on Mondays or Fridays at noon for us.
Okay. How's May 17th work for the parties' calendars?
I'm here then, Judge.
Okay.
That's fine.
Okay. I will set this then for May 17th for a trial at noon.
Anything else, Your Honor? I don't think
I appreciate it, Mr. Ashworth. Enjoy your weekend.
Thank you. Thanks, sir.
Judge, he's asking me.
Hang on, Mr. Ashworth.
It would be possible to remove the ankle bracelet. He's had it on 6 months or more.
7, yeah.
There's been no incidents.
Well, that's not necessarily true. There's been some problems reported by the victim. The victim's in attendance today. Before we give me a second, I can see if we can get some feedback. First impression.
Yeah, that'd be fine, Mr. Ashworth. 17. I can tell you, being this close to trial at this point, I would, in my inclination would be to not grant that request because we are close to trial. Unless I were to hear some other agreement between the parties, and it doesn't sound like there's going to be an agreement.
No, Your Honor, maybe some time since the last continuance due to family being sick, but I don't think that the victim, who is, of course, the boss here for me, is going to agree to that. So I apologize, but then I'm going to have to object to that.
Okay. Mr. Roadcrap, I'm going to deny your request because we're within a month from trial. So on May 17th, you're going to have your trial, and then at that point, whether it be Judge Capper or whether it be me at that point, we'll be able to make a decision on what happened with the ankle monitor based upon what happens at the trial after hearing the evidence.
Thank you, Your Honor.
Thank you, Mr. Ashworth. Have a good weekend.
State of Ohio versus Anna Marie Collins, case number CRB 24169.
The State of Ohio versus Anna Marie Collins, CRB 24169. And the matter looks like it was set as a pre-trial today. Anna Marie Collins. All right, well, Mr. Morford is present on behalf of Ms. Collins. Ms. Collins has failed to appear. The time is now 11:30. It's set for 10 a.m. Mr. Morford, any idea where your client is?
No, Your Honor, I don't.
Okay.
If I could get a week before they issue a warrant, I'll try to get a hold of her.
I will go ahead then and issue a warrant for failure to appear. And have the clerk hold it for 7 days prior to issue.
Thank you, Judge.
Thank you, Mr. Wilford.
State of Ohio versus Jatana K. McFan, case number CRB 24157.
This is State of Ohio versus Jatana K. McFan, CRB 24157. McFan is present with her counsel, Mr. Morford. State of Ohio is represented by Mr. Heald, and this matter is set for a pretrial today.
Your Honor, I believe my client wants to have a change of plea this morning.
Okay. What plea does she wish to enter?
She's going to enter a plea of guilty to the complaint, Your Honor.
All right. Ma'am, is that true?
Yes, Your Honor.
Okay. I'll accept your guilty plea and her guilty finding. And before we do sentencing, I'm going to have Mr. Fan do a urine screen, and then we'll recall the case after we've got the results back.
Thank you, Your Honor.
Thank you.
State of Ohio versus Jason Messer, case number CRB 23461.
The State of Ohio versus Jason Messer, CRB 23461. Matter set for a pretrial today. Mr. Messer's present. I don't see any attorney listed. Mr. Messer, were you intending to hire an attorney?
No, sir.
Okay. Did you wish to be considered for appointed counsel?
No, sir.
Your Honor, this is one that I believe I know something about at this point in time. The last time we were here, it was suggested to Mr. Messer that we would agree to do a 90-day continuance and dismiss the charges upon the payment of court costs if there weren't any further problems. And at that time, Mr. Messer declined that, but I think maybe he's reconsidered that, and he also had a question about sealing the record of a dismissal, and I told him that we would not oppose such a sealing of the record when the time comes.
A dismissal can be sealed.
Yes, so if that's what he wants to do, then we're agreeable with all that.
Yeah, when I was here the first time, I had some misunderstandings with how everything worked and keeping my record clean. So I actually got some advice on all this stuff, so I would like to continue with the dismissal.
Okay. What I'll do then is I will set, I've already set a couple of other ones of these for about 90 days out, which is July 26th. It's going to be a pretrial at 10 a.m. I'll note that if there are no further problems between the parties, that the case will be dismissed upon payment of costs.
I'll pay that today. I do have a question on that. On that 90 days out, would I have to show up? Do I have to show up if there's no issues? And I ask this only because I may be 1,200 miles away working.
I tell you what, Norm, the problem we have is with you not having an attorney, we don't have anybody that can just reach out to you directly. But what I will do is allow you to appear via Zoom.
Okay.
You can do that right from your phone.
Yeah.
And so if there's no further problems, or if the case presents, or if the state presents a dismissal prior to then, or at that morning of hearing, then you wouldn't have to appear. But if not, I need you to appear on Zoom and to make note for the record that there are no problems.
At the arraignment, back on April the 5th, the young lady who's the alleged victim came before the court and wanted us to drop the charges immediately. She didn't want a protection order.
Okay. That was my next question. Was the victim on board with this?
If he pays the court costs today, then we would go ahead and dismiss the charges today.
Okay. I've got no issue with that. Then, can you pay the court costs today, sir?
Yes.
All right. It'll be dismissed upon payment of court costs.
Your Honor, does Mr. Messer understand that the expungement is not an automatic process that he would have to follow?
Yes.
Plan?
Yes. I've done a little more research. That's why I was like, no.
Not a problem, Mr. Messer. Pay the court costs, this matter will be dismissed.
Sir.
And you can choose to take any action, whether you wish to have the record sealed from that point, after that point going forward.
Yes, sir. Thank you.
Thank you.
Y'all have a good day.
You too.
State of Ohio recalls Danielle Ham at the Lawrence County Jail, case number CRA 24229.
This is State of Ohio versus Danielle Ham, CRA 24229. This matter is Mr. Steyer is in the courtroom present, and Ms. Ham is present via Zoom at the Lawrence County Jail. Ms. Ham, can you hear me?
Yes, sir.
All right, Mr. Steyer, you've had this matter recalled on the matter of bond. Is that
I have, Your Honor. I've discussed the matter with Ms. Ham. She does not believe there's any cash or surety bond she can make, or she has asked me to seek an OR bond, so I'm going to ask for that. She is a local resident, longtime local resident, has ties to the community. I think an OR bond would be appropriate in this matter.
Okay. Mr. Heel?
We believe that the bond that was set previously is appropriate. We also are going to request a protection order.
We would agree to the protection order in the event of the bond produced, Your Honor.
All right. Well, here's what I'm going to do. I'm not going to find that an OR bond is appropriate in this matter, but I will reduce the bond to a $10,000 cash assurity bond, and I will grant the protection order, or order the protection order in the matter. Who's the alleged victim in this, Mr. Hill?
Who's the alleged victim, Jasmine?
He says it's been Laura Thompson.
Laura Thompson.
Okay. So I'm going to order, ma'am, that you have no contact with, whether it be social media, phone, in person, or anything, with Laura Thompson.
I would, Your Honor, and after this is resolved,
Ma'am, we're on the record. It's better if you don't speak.
okay.
So we'll be back if you make the bond, ma'am, or whether you make it or whether you don't, we're going to be back May 3rd, 2024 for your preliminary hearing at 10 a.m.
Thank you.
Thank you.
State of Ohio versus Michael Davis III. Case number CRB 24-215.
This is State of Ohio versus Michael Davis III.
But you don't have custody.
CRB 24-215. President of the court is Mr. Davis, along with his attorney, Mr. Steyer, and Mr. Hill is representing the state of Ohio. And it also looks like the complaining party may be here as well. Just handed a treatment update.
You have more victims.
Yes. So I need to speak.
Anything else to add to the?
He did successfully complete OVP, and then this little mishap happened, so after that, he did go and have the assessment done with OVP outpatient, and he's been compliant since then.
Okay. Good report.
As long as she's not there, you're okay to be there. All right, well, you can call the police on that if you want to.
There are a number of cases here pending that involve Brandy Traylor. Ms. Traylor has expressed repeatedly her desire to drop those charges and any protective orders that involve her. This latest charge obviously does not involve Ms. Traylor. It involves the individual in the pink shirt there. I'm not sure where we stand on that.
I understand that, but that's not what we're here about today. If we have a trial, you're free to testify to that.
This is our first pretrial on this matter. I think a protective order has previously been granted. We have no objection to that protective order. I don't know if the state has anything to add at this point.
Well, we have at least one charge involving Brandy Traylor as a victim, and now we have Brandy's daughter as a victim. So it's not getting any better. And if we had an agreement in the other cases that we would dismiss those upon no further problems, and maybe treatment, I'm not exactly sure, I don't have that file in front of me, but that's not looking like a sure thing anymore as far as we're concerned.
Well, at this point then, Your Honor, I think it'd probably be useful to have at least one more pretrial to give me a chance to file discovery. We can set at least the matter involving Miss, I'm sorry, what's the?
I was going to say, Mr. Steyer, you know when they're coming back on the other cases?
Lindsay, no, we were set on another date, but then they are consolidated onto today. So we don't have another date
I only
back.
actually have the one file today, so.
Still set for May the 3rd in the computer.
Oh, well, then they're set for May the 3rd. When this was set, Judge Capper said to reset everything to today.
Okay.
Yeah, it's not a big deal.
Well, let's do this. Let's consolidate and set all cases on the same day. The 3rd is a little bit crowded.
We're already on the 3rd, apparently.
let's do that then. Let's just add this onto the 3rd. And that'll be set for a pretrial. That'll give you an opportunity to file discovery, Mr. Steyer, and to consult with the state of Ohio on different things. Mr. Davis, I am encouraged that you immediately went and sought treatment in this, and I hope that you stick with that treatment. It's not currently court ordered, I don't believe, but I do hope that you would stick with that treatment, and sticking with that treatment will likely have a positive impact on your case with the prosecutor rather than a negative one.
Yes, sir. I'm on medicine too, so like Vivitrol and stuff like that.
I read in the report that you're on that. Mr. Hill, do you?
The young lady mentioned that she still has clothes and everything she needs from the residence. We'd like to have cooperation on that. Get her stuff.
It's not his residence, it's Ms. Traylor's residence. Ms. Traylor says she's willing to have her there to pick up her belongings if she's accompanied by law enforcement. Ms. Traylor has just informed me that the alleged victim has stolen items from her already, and she's afraid of that happening again. I've advised that she would need to speak to law enforcement about that if she wants to fill out a police report. But at the moment, she's not willing to have her there without accompaniment. Is there somebody, a third party who could come?
If somebody could come, that would cause a problem.
Yeah, my mom can come here with us.
My brother can come with me if I have to go down there.
You don't get to
That's the issue.
You don't get to say.
Hang on. Everybody stop. So I can't order, anybody who's not a defendant to cooperate, but
Just have the sheriff to go with them.
however you guys want to set it up between yourselves,
I don't want
that's fine,
anything else
whether it's
said or
sheriff's
not,
deputy,
so
whether that be an acceptable third party, whether that be Ms. Traylor, bags the clothes up and has them ready to go and on the porch, and nobody comes in and has any contact, or a whole bunch of options that, reasonable adults can take.
I just don't want any incidents to happen.
But I can't order anybody other than the defendant to do anything. So I trust that you guys will be able to be reasonable adults and work this out amongst yourselves. We'll be back on May the 3rd at 10 o'clock. That'll be, if it's not clear for everybody, that will be all cases.
All cases.
Thank you.
Thank you.
So, you guys want to stick around, I'm talking about other cases.
State of Ohio versus Kristen Michelle McAllister, case number CRB 24203.
I'm sorry, I didn't hear what you called. I apologize.
Kristen Michelle McAllister.
Thank you.
All right, this is State of Ohio versus Kristen Michelle McAllister, CRB 24203. This is Mr. Steyer's case. Ms. McAllister is present, and Mr. Heald is here on behalf of the State of Ohio. You may approach.
Yeah, this is 426. Okay.
Thank you. Just been handed a progress report dated today. Okay, I have one question about this. There's one thing it didn't say. It says she's submitting to screens, but it did not indicate whether that she was possibly protected.
Okay, our other court liaison wrote the report, her screens have been clean.
Okay.
We had no issues, yeah.
Okay.
And, Your Honor, this matter is one, it's, discovery's ongoing, we need to ask for another, pretrial date, and in the meantime, we have, a positive report.
That is correct. Mr. Heald? Anything you'd like to add?
Nothing else, Your Honor.
All right. Mr. Steyer, I believe you're here the 24th
Of May,
of May.
I am.
Okay. At the defendant's request, this matter is going to be continued to May 24th at 10 a.m. for retrial.
Thank you. Good job.
Thank you.
State of Ohio versus William Spalding, case number CRD 23512 and PRD 23697. William Spalding.
The State of Ohio versus William Spalding, CRB 23512, PRD 23697. William Spalding.
Your Honor, I've not seen Mr. Spalding here today.
Okay, Mr. Steyer is present on behalf of his client, and Mr. Spalding is not here. Mr. Steyer, any contact with Mr. Spalding, or?
I have, but not regarding today or his ability to be here. I mean, not today have I heard from him. I'm not certain why he's not here.
Okay. I'll note that the time is now 11:50. Mr. Spalding was scheduled here at 10 a.m. And that Mr. Spalding has had a long history of failing to appear for hearings. So there'll be a bench warrant issued.
I take that back, Your Honor. I'm looking. He actually did. He told me he's in Florida and didn't know if he'd be back by the end of the month. I told him he needed to be here.
Okay.
So again, I will advise him that he has 7 days before a warrant goes out.
Okay. Bench warrant will be issued, and we'll see if you can get him back, Mr. Steyer. Thank you.
Thank you.
State of Ohio recalls Jatana McFan, case number CRB 24157.
All right, this is State of Ohio versus Tana K. McFan, CRB 24157. The defendant's present with their counsel, Mr. Morford, and we are recalling this matter for sentencing. There was previously a guilty plea entered earlier today. We had Ms. McFan screened, and Ms. McFan was negative for all substances, which is good. So, Mr. Morford, are you ready to proceed to sentencing?
Yes, Your Honor.
All right. It'll be 10 days in Lawrence County Jail, all suspended. It'll be $100 fine, or you pay the court cost, 30 hours community service, and it'll be 2 years level 4 probation. Was there any restitution in this matter, Mr. Hill?
No, Your Honor.
Okay. And there'll be no restitution ordered. So, ma'am, you'll need to speak with probation before you leave.
I'll give a review date, Your Honor.
October 25th, Your Honor.
Okay. Review October 25th at 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you.
State of Ohio versus Gary L. Calico, case number TRC 24519, A, B, and C. Mr. Haskell.
Your Honor, Justin Haskell for Calico. He's scheduled for 12 o'clock today. He may be out all day.
Okay. Let me call for him real quick. Gary Calico. Gary Calico, if you're in the lobby, please come in the courtroom. We'll give him a second. If not, we'll recall it.
I'm sorry, I did speak with him like a couple hours ago. He's definitely coming. He's right outside with it.
Okay. We'll recall this here shortly and give him an opportunity to arrive. We're a little early on that.
No problem.
Thank you, Mr. Haskell.
State of Ohio versus Jared Nolan, case number CRB 24160, A and B.
This This is State of Ohio versus Jared Nolan, 24160 A and B. Mr. Nolan, I have a note that you were not eligible for an appointed attorney when you were originally here, and we're set for a pretrial here today. Have you had an opportunity to seek counsel?
No, sir, I can't afford it.
Okay.
I work 40 hours at Toyota through a subcontracted company. My checks are usually about $650 a week. I have 2 kids and a newborn on the way.
Okay. Based upon that, I'm going to find that you now qualify for counsel, and I will appoint Mr. Roger Smith to represent you. And Mr. Smith, given that you are unfamiliar with the case, I presume that there's not going to be anything that we can do today. We're going to be asking to move it for another day.
I would, Judge, I will file discovery if we'd come back another day. He's obviously on the bond, either signature bond or, did you post it on?
There was a bond posted through Mr. Sowers.
We'd ask that bond continue. We'll waive time until the next hearing. I'm here the 20th or 24th of May.
Set it for the 24th. Be a pretrial at 10 a.m.
I'm ready to go. I'll give you a call.
I appreciate it.
Sure. Yeah.
Should we let him out? I guess you can decide. Should we let him out on this? Yeah. Okay. So I'll have him take the record and then we'll let you change that. Do you need to look at this before I go do the protection?
State of Ohio versus Kyle White, case number TRD 24599 AB.
This case, State of Ohio versus Kyle White, TRD 24599 A and B. I have a note here about Mr. White, you were going to attempt to hire your own attorney.
Yes, Your Honor, I had attempted to, I just couldn't afford one. I make around $1,000 bi-weekly. I work at KDMC.
Did you say $1,000 bi-weekly?
Yes, Your Honor.
Have any dependents?
No, Your Honor.
You do not currently qualify for appointed counsel. How do you wish to proceed? Do you wish to have more time to try to come up and be able to hire an attorney? I'll give you more time if you...
That would be okay with you, yes.
Okay. This is Kyle White, TRD 24599 A and B. Yes. All right, I'll give you till May 31st. I'll set it for a pretrial at 10 a.m. I'm going to charge the time to the defendant as it's at his request, and that'll give you some more time to try to come up with funds and/or talk to some attorneys.
Thank you, sir.
What was that date we run?
May 31st.
State of Ohio versus Trevor DeMint, case number CRA 23514, CRA 23380, and others. Dyer's case, he should be on Zoom, Your Honor, with this Trevor's iPhone.
Yes, and he has a letter in his file already that was emailed in.
Okay. Give me 1 moment here. This is State of Ohio versus Trevor DeMint, CRA 23514, CRA 23380, CRB 21167, CRA 2321, CRB 2324, CRB 19667, CRB 19570. Mr. DeMint, can you hear me?
Yes, I can.
Okay. Let me review this report.
Good.
Okay. And I noticed on the 425 screen there was a positive for buprenorphine. Is that prescribed?
Yes.
Okay. All right, that's a fantastic report, Mr. DeMint, and you picking up the job. It could be a game changer for you. So that is wonderful news. I'm going to continue this matter. All cases before the court to May 31st, 2024 for pretrial. And keep doing what you're doing. Keep working through your treatment. And stay compliant and stay in contact with your attorney.
Yes, sir.
All right.
I'm sorry I couldn't be there. Just starting this job, sir.
That's okay. The report's wonderful. I have no issue with that, and I want to see you make a good living and keep your job. So that's important. Stay in contact with your attorney, and we'll have you back May 31st, 2024 for pretrial at 10 a.m.
Thank you.
Thank you, Your Honor.
State of Ohio versus Jonathan Jones, case number CRB 22686, CRA 22685, CRA 23679.
All right. This is State of Ohio versus Jonathan Jones. President, of course, Mr. Jones, and his attorney, Mr. Steyer. State represented by Mr. Keel. Good night. Thank you. All right, well, mixed bag. Mr. Jones, I'm encouraged by your negative screens on everything, but I'm a little discouraged because it appears you got a pass and you didn't return initially.
Yeah, it was 23 hours late.
Okay. Well, it's very important when it comes to these that you follow the rules, because that can result in you being removed from the program. So, but I'm very encouraged on that. Mr. Steyer, do you want to come back on 31st?
That'd be fine, Your Honor.
Okay. We'll come back for pretrial and preliminary hearing at 10 a.m. on May 31st.
Thank you.
Thank you.
State of Ohio versus Melissa Snell, case number CRA 23224 A and B. Mr. Morford's case.
So the State of Ohio versus Melissa Snell, CRA 23224 A and B. Present in court is Ms. Snell with her attorney, Mr. Morford, and Mr. Heald on behalf of the state of Ohio. You may. All right, I've just handed a report from Hometown Recovery. There were a couple of positives on the screen. Were those for prescription medications?
With both of the prescribed meds. She's got
Pretty
one
sure.
that's cyclic.
Yes.
Okay. Just wanted to be sure on that. Ms. Snell, it's a really good report. You're doing a good job. You're doing exceptional. Mr. Morford, you want to pick another date to come back?
Judge, work for your convenience. She's doing well.
Why don't we come back, let's do the 20th of May. For a preliminary hearing, 10 a.m.
Thank you.
Thank you, Mr. Morford. Good job, Ms. Snell.
State of Ohio versus Natalie Hall, case number CRA 24177.
All right, this is State of Ohio versus Natalie Hall, CR 24177. Ms. Hall is not present today. I'll call for one more time. Natalie Hall, if you're in the lobby, please come to the courtroom. All right, I'll note the time is now 12:06 p.m. Ms. Hall was scheduled to be here at 10 a.m. Note that Mr. Sowards, there's a bond up with Mr. Sowards. Mr. Morford, anything you've got to say on this one? I noticed there was a note that no witnesses were required today. But I presume that's the state's witnesses.
I believe so, Judge. This is one, I think, where we have an eye towards letting her go to treatment and possibly resolve it in a less severe fashion than going to Ironton. I cannot tell you where she is today, Your Honor.
All right, I'll note the failure to appear. I'm going to issue a bench warrant in this matter.
You give me a week before that.
Well, given the...
We'll need a bond for.
Yeah. Yeah, we'll set a bond forfeiture hearing for May 31st. At 10 a.m. we'll notify Mr. Sowards.
I will notify Mr. Showers, Your Honor. I'm sure that he will have her before that day.
Mr. Sowards is part bloodhound. I'm quite confident in his abilities. Thank you, Mr. Morford.
State of Ohio recalls Gary L. Calico, case number TRC 24519, A, B, and C.
All right. This is State of Ohio versus Gary Calcote. Mr. Calcote is now present in court. His attorney, Mr. Haskamp, is present via Zoom, and the State of Ohio is represented by Attorney Philip Heald. Gentlemen, where are we on this matter?
Your Honor, Mr. Haskamp and I spoke about this case and reviewed all the facts and everything prior to the hearing early this morning. And I believe that Mr. Calcote would intend to change his plea on the OVI to guilty. If he does that, we would move to dismiss the other two pending charges.
Okay, is that correct, Mr. Haskamp?
That's correct, Your Honor.
Okay. Mr. Calico, could you hear what was represented to the court?
Yes, sir.
Is that correct?
Yes, sir.
All right, so I will accept your guilty plea on the A case, enter a guilty finding. Was there any specific resolution you guys had discussed as far as fines or jail time? Or?
Your Honor, we have no opposition to the court imposing the minimums that are required under the circumstances. We would want Mr. Calico to attend the 3-day driving school instead of going to jail. We take no position on the number of jail days that would be reserved or suspended. As far as the fine goes, it is marked as a refusal, but really under the circumstances, probably it was more they just didn't see a practical way to cause him to do the test. So we don't have a problem if it's not considered a refusal.
Okay.
Your Honor, does Mr. Calhoun have proof of insurance? The computer file notes that he didn't have it at the time.
I don't have it on me, but I can get it into the court.
Okay. You probably won't need to get that in by close of business today at 4 o'clock, or else you'll have to deal with the B&V, which is a lot more difficult.
All right.
Okay. Mr. Haskamp, you hear what Mr. Heald had indicated to the court?
Yeah, Your Honor, as I understand as well, Mr. Hill and I also discussed if the court was open to the possibility of a 6-month license suspension instead of 12, if the court thought that was appropriate.
Okay.
We're not opposed to that, Your Honor.
All right. So what I will do, let me take a look real quick. All right. I'm going to impose 10 days in jail. I'll suspend them all on the condition you go to the 3-day driver intervention program. There'll be a minimum $375 fine. I'll leave the court costs. There'll be 30 hours community service order. I will impose a 1-year license suspension dating back to March the 10th, 2024, but suspend the second 6 months of that sentence, of that suspension. And the B case and the C case will be dismissed. There's going to be 2 years, level 4 probation, and we'll set Mr. Calico review hearing, and that will be October 16th. Is that the date?
25th, Your Honor.
Okay, October 25th at 9 a.m. And Mr. Calico, if you have everything completed by that time, you will not need to appear for your review hearing. If you don't, if there's anything remaining, then you got to appear for the review hearing.
All right.
Okay. Anything further, Mr. Paxton?
Your Honor, would the court, I think my client will try to take care of the court, so my client would like to apply that role in the driving privilege as well during the suspension.
Okay, I'll grant limited privileges. That'll be for, if he's working for work, it'll be for court, the DIP school, and any type of medical concerns.
And Your Honor, that's with proof of insurance, correct?
Yeah, he's going to have to provide his proof of insurance, though, before that will be granted. But he'll need to do that to keep the B&B from coming after him, so he indicates.
He's also a father for me, single father for 3 years. He does shopping for the family, so we're granted the ability to, get groceries and that type of stuff. That would be very helpful.
Okay. And I'll list for family shopping. As well. Anything further, Mr. Hasselkamp?
I'm sorry, Your Honor, could you repeat that?
Anything further?
No, Your Honor, thank you.
Thank you, Mr. Hasselkamp. Anything further, Mr. Gill?
No, Your Honor, thank you.
All right, Mr. Calico, you'll need to see the probation department before you go, and then you'll need to go get your insurance and get it down here. Once we've got your proof of insurance, then we'll be able to give you your driving privileges at that time.
All right, once I obtain that, where do I need to bring it back into you at?
The clerk's office.
Okay.
They'll be able to take care of you over at the clerk's office.
All right, thank you.
Thank you.
State of Ohio versus Daniel Smith, case number TRC 21-1460 A and B, separate sentencing, Your Honor.
Okay. This is State of Ohio versus Daniel Smith, TRC 21-1460 A and B. We're set for a sentencing hearing today, and Mr. Smith is present. And it looks like maybe you're unrepresented. Is that, do you have an attorney?
No, sir.
Okay. And it looks like that you have, you had a previous case, this case has been outstanding for a little while. You owe 18 hours of community service, and that you owe $310 on the case balance. I don't know if I've got, this is March 25th, the form listed here.
Your Honor, I think what happens sometimes with these sentencings is they don't get updated because they're not like a review docket. So he does owe $210 now, and I'm not sure on the community service. It looks like he had that all completed, and he's working towards monies on fines.
Okay.
So should the community service completed and owes.
Well, Mr. Smith, you
210.
You owe $210.
Yes, sir.
I don't know if you've been informed, but they're doing double days
I'll be here
on Saturday for the next 2.
Yep.
So if you do both of those double days, you'll be down to $10 owed, and then when you come back, we'll be able to close out your case.
Yes, sir.
So I'm going to go ahead and continue this till the 20th at 10 a.m. on May at 10 a.m. And if you've got everything knocked out by then, you'll be able to close your case out.
All righty.
All right, thank you very much. We'll see you back on the 20th at 10 a.m.
Yes, sir. Thank you.
Thank you.
State of Ohio versus Andrew Carr, case number CRB 24-7.
Get a good report today.
I don't have anything on paper for it. Okay, that's fine. Good report. Okay, everything's good.
This is State of Ohio versus Andrew Carr, CRB 24/7. President of court is Mr. Carr with his attorney Roger Smith, and Mr. Hill on behalf of the State of Ohio. This matter set as sentencing.
I think we're going to have an oral report. There's not a written report, but apparently he's doing well. I'll let the counselors speak.
Yeah, Your Honor, he's with us. He's been with us now for a little over a week at the counseling center. He's set to complete Detox today and move on to our residential program.
Okay. Compliant?
Absolutely.
Judge, given he's going to complete detox, start the residential portion of the program, I would ask you to come back the 24th of May. That's about a month out, and see how he's doing.
Okay. We'll come back for a sentencing hearing on May 24th, 10 a.m.
Thank you, Judge.
Thank you.
State of Ohio versus Kevin E. Conrad, case number TRC 231155 A and B.
The State of Ohio versus Kevin Conrad, TRC 231155 A and B. Mr. Conrad is present in court today with his attorney, Mr. Stratton, and Mr. Gill on behalf of the State of Ohio. I believe we're about to get an update report. Beverage. Thank you, Mr. McKinney.
Sounds great. When do you think you'll be done?
It's one of the better reports I've seen in a while, Mr. Conrad.
Thank you. Feels very good, Your Honor. He'll be done in a couple of months, so I don't know if you want to send it out that far or not.
I don't want to go out quite that far, but let's go to May 31st for sentencing.
May 31st.
All right. 10 a.m.
Thanks.
State of Ohio versus Linda L. Carpenter, case number TRC 231792 A and B. Mr. Steyer, case.
This is State of Ohio versus Linda Carpenter, 23792 A and B. Ms. Carpenter is present with her attorney, Mr. Steyer. Mr. Gill on behalf of the State of Ohio.
Your Honor, we have been pursuing a rehabilitation center for Ms. Carpenter. We have not had much luck with that for a period of time due to a combination of issues involving her health and her insurance coverage. But she has, with the help of Land of Goshen, she's found a facility. She's going to go either Sunday or Monday of this week. I've had her meet with Mr. Major to go ahead and fill out a HIPAA compliant release, as well as get his card, so that if the agency doesn't want its own release, she has his information to fill in. At this point, we need to get a continuance. I don't know how far out we would want to go. She should be in somewhere next week, but it might be worth going a little further out, both because I know the docket's getting heavy and because we might get a little more information at that point.
Let's do May 31st.
Yeah.
Okay.
So
write that down.
May 31st, for sentencing at 10 a.m.
And make sure you give that information to the providers, so they know to get you here that day.
Yeah.
And you got my number, so they can talk to me if they need to. You fill out
Yeah.
a release for that. Thank you.
State of Ohio versus Samantha Rush, case number CRB 2436.
Thank you very much.
Thank you.
The State of Ohio versus Samantha Rush, 2436. Mr. Rush is present here in the courtroom. This is set for sentencing and being handed a report from Southern Hope. Very good report. Very good report. How long has she been with you at Southern Hope? I see at least one other.
February 23rd, it says here.
Okay.
That sounds about right. I was out for about 8 weeks with some personal issues, so she came in the program while I was gone.
Okay. Any idea on the completion date?
We're usually a minimum of 6 months.
Then she's done so well, I want to go out just a little bit further on this. All right. We're going to come back on June 7th for sentencing at 10 a.m.
Okay, thank you.
No problem.
Thank you.
Keep doing what you're doing, and you're, that's a great report.
Thank you. Have a great day.
You too, thank you.
State of Ohio versus Joseph D. Whaley, case number CRB 23-521 A and B, CRB 23-419, CRB 17-170, CRB 17-133.
Yeah. All right. This is State of Ohio versus Joseph Whaley, 23-521, A and B, 23-419, and 17-160, and 17-133. Mr. Whaley is now present in court with his attorney, Mr. Steyer. State of Ohio is represented by Mr. Keel. This is an arraignment on a failure to appear.
Your Honor, Mr. Whaley contacted me on the day of his failure to appear. He informed me and I informed the court that he was ill. He tells me now that he actually had COVID. He's here now though, and he got himself in here under his own steam. So I'm gonna ask that the warrant be withdrawn.
Okay. Mr. Keel?
As much as I want to help Mr. Whaley along, because I know that he's had struggles in life and I know he's trying to do better, this business of just not showing up and then showing up a week later, one of the people that's a victim in this is very frustrated by that, because she shows up on the dates where he's supposed to be in court and then he's not here, and it makes it look like to her that like we're not trying to do anything. Trying to see that justice is done. What we had planned to do on April the 19th, when Mr. Whaley did not show up, was to offer a plea agreement to settle the case. And our agreement, our recommendation would be 60 days in jail, suspended, 2 years probation, continue on with his counseling, and the restitution that would be ordered in with the criminal damaging charge with Ms. Toman as the victim on that, and that's $1,000. Restitution would be due. So that would be our recommendation today, or we just need to set it for a trial.
Then we need to, you gotta come back.
And that would cover all the pending cases.
Well, that covers everything, though, so that might be worth doing for that reason. But it's up to you.
Okay. He knows that.
That's fine. You want to do that? That's fine. Your Honor, based on that offer and anticipating that the court would accept that offer, Mr. Whaley is willing to enter a plea of guilty at this time.
Mr. Whaley, is that correct?
I mean, if it's going to please the courts and get this over with, I don't know, because I've never touched this lady's car, but I don't want to drag this on any further and cause more problems. I'm just trying to get into my treatment program like I'm supposed to be doing.
Well,
but every time I come in, I keep tacking on more fines. Like, I'm never going to be able to get my license back this way. It's so hard to work and get here. Like, I stay in Proctorville. Like,
Well,
it's tough.
what I can't do is I can't accept your guilty plea when you're telling me you're not guilty. So the only thing that I can do is set it for a trial.
Yeah, because I was just told to come in on a Friday. That's the reason it went a whole nother week. So it's not that I intentionally wanted to miss, but I don't want to get everybody sick in the courtroom either.
Now, I will note, Mr. Whaley, you have had a history, it looks like, from the file of not appearing over the course of time. And I certainly understand Mr. Hill's sentiments if he's got victims who are showing up and you're not showing up. You got to get to court when you're scheduled.
I've seen her one
And
time.
I understand there's some issues that come with
You haven't
that.
been here the day she's been here.
So what I'm going to do is go ahead and set this matter then for a trial, bench trial, on May 20th.
Okay, well, hang on.
I will recall the warrant, and we're going to set this matter for trial.
We're doing set it for the 20th?
Yes, if you're available. Mr.
I am.
At noon. And that'll be on all pending cases.
Your Honor, if I may, I did speak with him, agreed, he is going to inpatient treatment on Tuesday and has a bed waiting for him.
Okay. And there could be resolution at that time, potentially. But I think at this point, I'm kind of stuck in a position like we just need to set this for trial and see where it goes from there.
All right, I'll talk to them. Well, I need their names so I can subpoena them. So I have the names and the phone numbers. You can hold on.
State of Ohio versus Agnes Sexton, case number CRA 24209, CRB 24210, CRB 2349 A and B, CRB 22740.
May 20.
This is State of Ohio, you're right in front of that block. The State of Ohio versus Agnes Sexton, CRA 24209, CRB 24210, CRB 2349 A and B, CRB 22740.
Your Honor, I guess okay. Spoke earlier to, Officer Chen's here. He is agreeable, as the victim in this matter, he's advised me that he's agreeable to the case remaining here if Ms. Sexton goes on to treatment. The state, based on the recent situation, wants an ankle monitor for that, which we're agreeable to. But as a practical matter, I believe there are none available. The entire set of 10 that the court has access to are in use, and there's actually one person that may be ahead of her, or maybe not. Heard Mr. Major talking about maybe that case is not on the police court. This was, it may not be still waiting for one of these monitors. But there's at least, all 10 are out now, so she's not going out today. I don't know how quickly we'll get a monitor available for her, so I don't know whether we want to set this back. But she is interested in keeping the case here, so we're willing to do what's necessary to do that. And of course, this is Mr. Smith's case. I don't know his availability. So if it's set, he can, let him know when it's set, and he can act accordingly.
Okay. Mr. Heel, I want to hear from you on this.
Well, I've spoken with Deputy Chen about this because he was the one that got bitten by her, which we consider to be very serious. And he's okay with the case remaining here without, we'll just continue the cases. And in the end, it wouldn't be a situation where we would just dismiss the assault case, but we would agree to work it out as a misdemeanor in the end if she's successful in treatment. But if we got to there and she says, no, I'm still not going to plead, or, then we could still send it to the grand jury. It's serious enough. However, on the other hand, we want her in treatment. And I think it's pretty nice of the deputy to agree, after the behavior that she displayed and what she did to him, that he would be agreeable to that. So we're willing to extend that to her, but with conditions.
Well, here's what I would want to do before I do anything. I would want to have her screened and see what comes back in the screen. I don't know that you want to, you probably want to speak with your...
Negative, but I'll be honest, there will be swabs and did get involved with once or twice, don't know if that's up, but the cost on the street, that's what could, if any.
So we can test if you'd like, or we can just take her admission that there's going to be...
I want to see what's in, based upon her demeanor and her behavior, kind of here today in the courtroom as well. I want to know what's in her system.
That's fine.
Before we do anything with her.
Okay.
This matter will be recalled.